Section 363 sales provide opportunities for both strategic and financial purchasers. One of the main advantages of a Section 363 sale is that the purchaser can acquire the debtor's assets free and clear of virtually all liens, claims, and encumbrances. Additionally, Section 363 sale orders contain findings that shield a buyer from liability, including that the sale was conducted in good faith and that the purchase price constitutes fair consideration for the assets, thus protecting the buyer from a fraudulent conveyance challenge. While there are many benefits to purchasing assets via Section 363, Section 363 sales present special rules and unique circumstances that can be a minefield for a buyer who does not fully understand the process. Today we are going to focus on 5 key issues buyers will want to carefully consider when engaging in a Section 363 sale. First, there is due diligence. While due diligence is important in any sale transaction, it is especially important in a Section 363 sale. Because of the company's financial situation, management may have taken aggressive or unusual actions in operating the business. Further, as is typical in Section 363 sales, most sales are conducted on an as-is, where-is basis, and there are generally no representations or warranties that survive closing or indemnification provisions for breaches. Due diligence is therefore important to identify any defects or unusual circumstances that may not be addressed through a free and clear sale order. Second is the good faith deposit. The Bankruptcy Code does not contain a requirement that a deposit be made in connection with submitting a bid. Notwithstanding this, it has become standard in most Chapter 11 cases to ask potential bidders to escrow a deposit with their bid. The requirement to do so, the amount of the deposit, and the terms upon which the potential bidder will get a refund of its deposit are set forth in the bidding procedures as approved by the Bankruptcy Court. Potential bidders will want to carefully review the bid procedures to understand when they will be entitled to a return of their deposit. For example, the bidding procedures may provide that bidders are not entitled to a refund of their deposit until the sale closes, which could leave a bidder's funds tied up with the estate for an extended period of time. Third, executory contracts and unexpired leases. One of the key advantages to a Section 363 sale is the ability of the debtor to assign most contracts and leases to a buyer, including contracts with anti-assignment language, so long as certain conditions are satisfied, including payment of all outstanding amounts owed under such contract or lease, which is referred to as the cure amount. There are a number of issues a potential bidder will want to consider in connection with the assignment of contracts. First, a potential bidder will want to ensure that the debtor serves notice on all counterparties to executory and contracts and unexpired leases that their contract or lease may be assumed and assigned as part of the sale, and that service of the notice conforms to the manner of service of a summons and complaint to avoid any arguments by third parties that service was defective. In structuring its bid, a potential bidder will want to consider who will pay the cure cost, the debtor or the purchaser, and whether there will be a cap above which the responsible party for making such payment will switch. Obviously, a bid where the purchaser is liable for all cure costs will be more attractive to the debtor. Third, especially where the potential purchaser is responsible for the cure cost, a potential bidder will want the flexibility to add and remove executory contracts and unexpired leases from the final list of assumed contracts and leases up to the date of closing on the sale. This will provide the purchaser with the most leverage in dealing with contract counterparties who may be willing to make compromises in order to avoid having their contract rejected. Fourth, closing the auction. A potential bidder will want to make sure that the bidding procedures require that at the conclusion of the auction, the debtor will announce the successful bidder and close the auction. Case law is clear that reopening an auction is in the court's discretion, and while a bankruptcy court may reopen an auction if a new bid is substantially better, this factor alone is generally not enough to warrant reopening the auction. By formally closing the auction, a potential bidder will have as much comfort as possible that the results of the auction once closed, are final. To this end, a potential bidder will also want language in the bidding procedures that provides that following the closing of the auction, neither the debtor nor its representatives will initiate contact, solicit, or encourage proposals with any third party with respect to the assets that are for sale. Finally, the purchase assets should include preference actions. Preference actions seek to claw back money paid by the debtor prior to the bankruptcy being filed and must generally be asserted within 2 years of the petition date. The target of such actions is often the debtor's former key suppliers and vendors who are now engaged in business with the new owner of the assets. Unfortunately, when this happens, the purchaser has little to no leverage to resolve these lawsuits. In order to avoid this, a purchaser should seek to include avoidance actions among the list of purchased assets. However, because preference actions might be the only source of recovery for unsecured creditors, a creditors committee may, in certain instances, attempt to either remove or limit the scope of this release or potentially seek additional consideration in connection with the sale of avoidance claims. Today we have discussed 5 key issues a potential bidder in a Section 363 sale will want to consider. While this list is in no way meant to be comprehensive, for example, we did not discuss today specific issues related to a stalking horse bidder, it provides a good starting point for understanding the pitfalls a bidder will want to address in connection with a Section 363 sale.